Well, ladies and gentlemen, it looks like we have a close to this epic saga that's been going on, at least on my channel, for several months now. From PC Gamer, judge dismisses antitrust lawsuit filed against Valve. Wolfire Games filed the lawsuit in April, claiming that Steam suppresses competition and charges excessive fees. And so the judge basically said, yeah, there's not enough evidence here to bring this to trial as an antitrust case. And so we'll look at the lawsuit after. But real quick, a history lesson. I said a few things about this case before. I said that it was going to get dismissed. I said that it was laughable. You could go back and watch those videos if you want a history lesson. Maybe I'll put the trilogy now into a playlist or something, because it doesn't seem like this is being covered by anybody else, but I find it amusing. Wolfire Games developed a game called Overgrowth. It's essentially edgelord furry simulator 2021, and it's not even done. It's like early access. It looks really garbage, and their other games look pretty garbage too, and they're trying to compensate for being a garbage developer. He also emailed me of the last video I made and demanded that I take it down because of the horrible things I said about him or whatever. So, hi. No. This is them trying to basically make up for the fact that they suck at marketing. Because I'm sure there's somebody that's going to play their stupid furry game. There's plenty of furries out there, right? So it's not completely insane to think that somebody would play the furry game. In fact, furry games tend to do pretty well, but not theirs. And maybe it's not marketing. Maybe the game just sucks. I don't know. I mean, it looks like it sucks. So they're suing Valve. They're saying that 30%, which is the fee that Valve takes, it wouldn't be. Wolfire's lawsuit also claims that Valve uses its near monopoly to charge an excessive fee to sellers, 30%, that wouldn't be sustainable in a competitive marketplace. Well, it's funny that because Origin exists, Epic Games exists, GOG exists, Humble Bundle exists, Green Man Gaming exists. So how then is that not sustainable in a competitive marketplace? Green Man Gaming sells games cheaper than Steam because they take a loss. I don't think that that's true. I think, in fact, that's exactly what you charge for a 30% is exactly what you charge in a competitive marketplace for advertising, servers for multiplayer games, as well as updates, feeding the updates directly to your player base, forums, community management, tech support, refunds. Valve will completely deal with your refunds for you. Marketing. If your game is good, it will market itself on Steam. All of these things. It's not worth 30%, huh? Okay, well, what does Apple charge on their platform to get into the App Store? You know, like, I wonder what their fee is. Oh, right, 30%. Well, maybe. What about Android? You know, the Google Play Store. What's their fee? Oh, right, it's 30% too. Huh. It's funny because the only one that's not doing a 30% fee is Epic Games. And maybe, just maybe, that's who funded this lawsuit. Big think. Anyway, looking at the lawsuit, you get the background on the case, and then that's, whatever. But the discussion in the legal standard, motion to dismiss pursuant Rule 12, to survive such a motion, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. Now, what that means for non-legalese is the standard of evidence here isn't beyond a shadow of a doubt, or beyond a reasonable doubt, or even the preponderance of the evidence. Does this seem like it could be true? Is it plausible? Because then you're going to do fact finding. Then you're going to do lots and lots of discussions and debates and back and forths and motions to get to the heart of the matter. But before you get at any of that, you have to say, is this plausible? Could it be possible? That's what this is saying there. So a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. That's important. In reviewing such a motion, the court accepts the truth of the facts alleged. That's important too, and draws all reasonable inferences from those facts in a plaintiff's favor. So, you say X, Y, and Z happened. The court is just going to say, okay, then if X, Y, and Z happened, then are the things that you're saying resulted from that plausible so that we can take this to the next step. However, allegations must cross the line between possibility and plausibility to entitlement of relief. Now, that's where you get into some tricky shit, because what they define as possibility and plausibility, there's a little bit of nuance there. It's up to the judge, and that's where a lot of people get lost, because it's one of those lawyery things. But basically they're saying here, is it plausible? If you laid this case out to them and everything you're saying was true, would you be able to bring this in front of a jury? Then the second part is the relevant market. And so what they're going to look at here is your claim is that in the relevant market, 30% is unreasonable. And so according to the CAC by 2020, defendant reported 45,000 Steam-compatible games and 120 million active monthly users, Steam platform users. The Steam store, where those games are generally purchased, presently accounts for 75% of the 10 billion PC desktop game markets. 75% is an important figure. What was decided in several cases, and that's basically what they're going through here, TradeCom versus Federal Trade Commission versus Qualcomm, as well as others. Basically, they're showing footnotes to other cases for precedent. So here the CAC presents two different market theories. Under the first, the Steam platform and Steam store operate in separate markets, i.e. a PC desktop platform market and a PC desktop game transaction market. Now, again, this is legalese, but what they're saying is that the Steam platform itself could be considered a PC desktop platform market, and then through that platform you buy games. So it would be two separate markets in terms of the government and how it sees it. Under the second theory, so this is a different interpretation, they operate as a single product in an integrated game transaction platform market. This distinction matters. Only a separate market theory would support the CAC's causes of action based on tying games. So what they're saying is, because you're tying the game to their theory is that you're tying the game to the platform, but they're two separate things. And that would make a monopoly, because instead of all PC games, 75% of the market share, right? You're now saying, well, 100% of Steam games require Steam. Therefore, that's a monopoly. That's what this is saying. I don't know if I'm explaining it clearly. You guys can tell me in the comments, or, if you think I'm wrong or whatever. But that's basically what's being said here. So the plaintiff is suggesting that 100% of Steam games require the Steam platform, therefore Steam is a monopoly. That's the claim here. Rather than 75% of the market is owned by Steam because it's the best PC gaming platform. And if you don't think Steam's the best PC gaming platform, by all means, leave a comment. Let me know what you think is. But Valve is kicking everyone's ass for very good reasons. In defining the relevant, this is some really heavy stuff. I don't know if I did a good job there, but I apologize if I didn't. In defining the relevant market, Wolfire and defendant debate the import of Jefferson Parish Hospital District Number 2 v. Hyde. In Jefferson Parish, the court articulated a consumer demand test to assess tying allegations. If separate independent consumer demand exists for tied products, then the markets encompassing those products are separate. Otherwise, they are not. So, if separate independent consumer demand exists for tied products, meaning if there is a demand that is separate, I have to have Steam as a platform on my PC. Also, I have to have these games that are only on Steam or only available through Steam. Then it would be a tied product. And this is where I said in my previous videos, although maybe not in this technical way, that the Wolfire allegations were complete and utter garbage. Because most, if not the vast majority, at least most of the big name releases that come to Steam also come on other platforms. And furthermore, now that you have GOG, which hosts a lot of old games that are on Steam, and Epic Games, which hosts a lot of platform-specific stuff that's only available on the Epic Store, and now the Xbox Game Pass, which harbors yet more games that are specific to that one platform. What you have, in essence, is that you can get those games as a consumer demand for those games through multiple sources, and some of them aren't even available on Steam. Therefore, the platform, the Steam integrated marketplace, aka just Steam, the app/program that you install on your computer, and then you can get the games somewhere else. Therefore, they are actually separate. They're not a tied product. Yes, 100% of Steam games that you purchase on Steam require Steam. But no, 100% of games, or even the 90 or 80% of games, are not tied directly to Steam. Circuit found that consumer demand test did not apply when the allegedly tied product is an essential ingredient to the overall method of business with customers. And that was decided in Epic Games Inc. versus Apple Inc. just a couple weeks ago. The court need not weigh in on the debate because under either standard, the CAC's allegations do not support Wolfire's contention that the game platform and game transaction markets are, in fact, separate. According to the CAC, games developed for a particular platform cannot be played on another platform, and with limited exceptions, game platforms generally do not charge for their use. Instead, they generate revenue to support the platform through the sale of platform-compatible games and in-app purchases. Granted, Steam-enabled games can be purchased on a limited basis elsewhere, like I mentioned, Green Man Gaming, Humble Bundle, but those games are of no value unless the publisher includes a Steam key, which defendant provides at no charge and only serves to allow the game to be played on the Steam platform. Therefore, under either Jefferson's Parish Consumer Demand Standard or Rick Mick's Essential Ingredient Standard, the CAC's allegations suggest that the Steam platform and Steam store are a single product with the integrated platform and transaction market. Yeah. They're basically, it's neither one of the things that I just spent all that time explaining. They're saying, yeah, no, Steam is just Steam. It's just Steam. You're talking about the game integration and the shell of the app itself as one thing, and then the games you buy on the marketplace is another thing, or maybe because they're tied together. But it's just Steam. It's just Steam, and you can go elsewhere and buy a Steam game activated on the Steam platform. It is its own thing, and that's one of the good things coming out of the Epic Games versus Apple lawsuit is now that's settled. That these storefronts are one thing. So finally, we get to the antitrust injury. To support an antitrust claim, a plaintiff must allege unlawful conduct causing an injury to the plaintiff that flows from that which makes the conduct unlawful, and that is the type of antitrust laws were intended to prevent. That's pretty straightforward. I don't think there's anything that needs to be explained about that. 1. Unlawful conduct. 2. Causes an injury to the plaintiff. 3. Flows from that which makes it unlawful conduct. So it has to, be caused by this. And 4. That is the type of the antitrust laws were intended to prevent. Obviously. Defendant's motion to dismiss focuses on the CAC's failure to establish the second element, causing injury to the plaintiff. Defendant's motion to dismiss focuses on that. The CAC asserts that the defendant's utilization of its monopoly power and platform most favored nation provision injures Wolfire through its payment of defendant's supra-competitive fee. It further asserts that defendant's coercive conduct reduces output and stifles competition in the marketplace, resulting in fewer, lower-quality games, as well as other ancillary anti-competitive effects. This is where I was like, this is just the stupidest bullshit I've ever heard. It further asserts that defendants' coercive conduct, their coercive conduct is, hey, everybody uses Steam. If you want your game to be seen by the most gamers, you're on PC, you're going to want to put it on Steam. That's them coercing. And then charging a 30% fee, like I said, to offer a variety of services, not just to the gamer, but also the developer. That it reduces output and stifles competition in the marketplace. Really? So you're going to make the argument that there are fewer indie games in 2021 than there were before Steam. How many independent games do you think came out in 2005, Wolfire Games Furry Boy? Let me know. Let me know what you think the answer to that question is. I'll tell you what the answer is. Resulting in fewer, lower quality games as well as other ancillary anti-competitive effects. So your claim is that there's less indie games and they're of lower quality than there was before Steam existed. That's a bold fucking claim, and it's no wonder you get thrown out of court. Turning to the issue of a super competitive fee, according to the CAC, defendants' fees far exceed that which it could charge in a competitive marketplace. For support, it describes defendants' cost structure and the lower fees charged by some of its competitors. By some, it meant specifically Epic Games. But the CAC also indicates defendant has always charged the same fee to game publishers, 30%. This began not long after 2001, when the PC desktop game digital distribution market was in the fledgling stage. Yet defendant did not become dominant in the market until 2013. That's true. Big box copies were still pretty popular right up until the early 2010s. Plaintiff's allegations are not meaningfully different from Summers versus Apple, where the Ninth Circuit found implausible the allegation that Apple's 99-cent music per download fee was super competitive. There, as here, the price remained the same throughout, even during periods of intense competition in the marketplace. While Wolfire suggests that a reliance on Summers ignores the Supreme Court's decision of evolving market realities, the CAC does not support this assertion. The market reality, at least as pled in the CAC, is that, in spite of defendants' super competitive fee, others who charge less have failed, even though they had significant resources at their disposal. EA, Ubisoft. Blown the fuck out. Therefore, it would appear that the market reality, at least as pled, is that the defendant's fee is commensurate with the Steam platform's value to game publishers. Get fucked. So this judge has just completely blown you out. The CAC also asserts that defendants' coercive practices result in non-price antitrust injuries, namely a reduction in output and quality. But the CAC lacks allegations supporting this assertion. If anything, the facts provided by the CAC, at least with respect to output, suggests the opposite. A consistent increase in the number of games available in the market and on the Steam platform. Moreover, as discussed above, to the extent that this injury is predicated on Wolfire's payment of defendants' allegedly super competitive fee, describing knock-on anti-competitive harms resulting from defendants' allegedly inflated price, is not adequately pled. And finally, the CAC does not provide facts describing how Wolfire directly suffered from an alleged reduction in output and or quality. Instead, it only addresses the impact on the industry as a whole. You didn't have a reduction in output. You put out your furry game just fine. It doesn't matter what some other indie... You want to do this? Do a fucking class action lawsuit and you'll still get blown the fuck out like you just did. This judge, at this point, might as well take a fucking check from Valve because he's playing their fucking goalkeeper. but it's because this is the facts of the case. In addition, the CAC describes other harms arising from defendants' practices, namely cybersecurity issues and a failure to police game consumers' inappropriate behavior. But it does not describe how those harms flow from that which makes the conduct unlawful or are the types of antitrust laws are intended to prevent. Yeah, so Steam doesn't ban users because they swear in your forum. You have to do that, right? And they're very butthurt about that. And also, cybersecurity issues, what they're claiming is, I don't even know what the cybersecurity, I've read the whole thing before, but I don't remember what they said cybersecurity issues was, but Steam's more fucking secure than most things you deal with online these days. To summarize, while the CAC provides a valuable alternative market to support its Sherman Act and CPA causes of action, the integrated game platform and transaction market, it does not articulate sufficient facts to plausibly allege an antitrust injury based on that market. Accordingly, the CAC fails to state a claim upon which relief can be granted. See, this is why you lefties shouldn't fucking file lawsuits if you just want to be a revolutionary. Because these Wolfire games, Furry Boy, you just got slapped down by a federal judge. Slapped the fuck down by the Honorable John C. Coffenauer. I think that's how you say it. Conclusion. For the foregoing reasons, defendant's motion to dismiss is granted and in part and denied in part. Wolfire's causes of action in the CAC are dismissed without prejudice and with leave to amend. Wolfire may file a second amended complaint addressing the infirmities described above, as well as any other changes it elects to make within 30 days of this order, dated this 19th day of November 2021. Wolfire Games, Furry Boy, if you've gotten this far, you need to listen to me now. Do not amend this complaint. This judge wants nothing to do with your stupid petty lawsuit. He did it in the most professional way possible, but he is very clearly telling you that you have no case and you're wasting not only his time but your own. But I hope that you do. I hope that you do amend this suit. You cannot address the problems that he said he has with your case. You can't change the reality in question of the super competitive fee. You can't change the reality of the so-called domination of the market or whatever. You're done, dude. Just pack it up. Take the loss. Take the L. Go home. Make a better furry game. Right? Make a bigger, better furry game next time. I've been working on some Unity dev. I could probably crap out a game that sells better than your shit. And I've only been working in game dev for like a month now. Anyway, you could do better. You could make a better game, and then you won't have to try suing fucking Valve. By the way, Valve has more lawyers on staff than you have staff. Good luck. Good luck. I hope that you try and amend this complaint. I don't think that you should. I think that you should take the L. You should take what this judge said to heart. You should maybe not even go on the Steam, make yourself a martyr. Say, we're only going to put out our games on itch.io or whatever now, you know? And maybe there's people out there that will buy your bullshit and buy your game, right? You know, more power to you. I don't want to see, I'm not like I want you ridden out of town on a rail or anything like that. You have provided me with endless entertainment making these videos and reading these lawsuits. So, what I would like is for you to make your furry game and have all the furries love it, right? That would be great. It's good for the market. It's good for everybody. I have a feeling you're going to refile this lawsuit, and we'll be back here for another video in a month. But as of now, it's been a trilogy. It's been fun. I'm probably going to put these in a playlist so that people can follow. The fact that I called this very clearly in the previous 2 videos and told you exactly what was going to happen, and the fact that you just got absolutely slapped down by Judge Kavanaugh, and the fact that PC Gamer cheerleading you on through this whole thing, they have to be laughing at you now. There are other legal points and precedents cited in the judgment, but the bottom line is Wolfire's lawsuit does not articulate... So yeah, that's an understatement, PC Gamer. As a result, Valve's motion to dismiss the lawsuit is granted, but only in part. I've reached out to Valve and Wolfire for comment on the case, and will update if I receive a reply. Yeah, I will update too. If he emails me again, I didn't do a video about it or anything. He emailed me last time and just told me to take the video down, and I just replied with, go fuck yourself. So, if he emails me again, if Furry Boy gives me an email, I will give a full breakdown on it, because this has become hilarious. He's basically my lolcow now. So, that's what we're doing. I'm glad that I got the chance to do this trilogy and keep you all up to date, and we will catch you when something interesting happens.